If you've ever been involved with probate in California, you already know how stressful, expensive, and time-consuming it can be. Probate can take a year, 2 years, and sometimes even longer. It involves endless court visits, stacks of paperwork, and mounting fees. Today, I've got some great news for you. Effective April 1st, 2025, a new law designed to simplify and shorten the probate process for many homeowners. Comment below if you have questions regarding the new probate law. So what exactly does this new law entail? Starting April 1st, 2025, if a homeowner passes away and their primary residence, the place they actually live in, is valued at less than $750,000, their family can potentially bypass the lengthy traditional probate process. This is a game changer because probate in California typically takes at least a year, often more. Now, for many Californians, this could dramatically speed things up. However, before you assume you qualify, there's a specific 3-step test you'll need to consider carefully. Here's how you know if you qualify under this new streamlined probate law. Step 1. Did the homeowner pass away on or after April 1st, 2025? That answer must be yes. Step 2. Was the property their main primary residence? Again, yes. Step 3. Is the home valued under $750,000 at the time of passing? Once again, this must be a yes. If you answered yes to all 3 questions, congratulations. You qualify to benefit from California's new streamlined probate process. Now, some people might think, fantastic, we can avoid probate, so no attorney is needed. Unfortunately, it's not quite that simple. Here's an example. Suppose your mom passes away without leaving a will and she has 4 children. Under California law, her estate is evenly divided among them. However, let's say one of your siblings previously passed away, leaving behind 3 children of their own. Now those grandchildren must also inherit it, complicating things significantly. The probate court still needs documentation clearly defining who inherits what percentage. An official property appraisal by a probate referee is also still required. An attorney can help to manage these formalities and ensure a smooth and accurate distribution. You might be thinking, with this new simplified law, do I even need a living trust anymore? The short answer is absolutely. While this new law simplifies probate, it doesn't remove it entirely. A trust, on the other hand, completely bypasses probate. Here's why that matters. Avoid probate entirely, no court, no delays. Privacy. Probate is a public process, whereas trusts are private. Control. You clearly dictate when and how assets are distributed. Asset protection. Probate protect your beneficiaries' inheritance from creditors, divorce, and lawsuits. For example, let's say one of your beneficiaries goes through a divorce. California's divorce rate hovers around 50%. Without a trust, your hard-earned assets could end up divided with your child's ex-spouse. A properly constructed trust prevents this. Estate planning is not only about after your passing, it's also about planning for the unexpected during your lifetime. For example, dementia, Alzheimer's, or sudden illness can leave you incapacitated. You need additional documents to complement your trust. Durable power of attorney authorizes a trusted person to handle financial affairs if you're incapacitated. Advanced healthcare directive clarifies your health care wishes and appoints someone to make medical decisions if you're unable. These documents ensure that you're protected both in life and beyond. Here's a crucial point many overlook. A living trust isn't effective unless properly funded. What exactly does funding your trust mean? It involves transferring legal ownership of your property to your trust. Here's how. Real estate. Retitle property deeds into the trust name. Bank accounts and investments. Retitle accounts into the trust. Personal property. Officially transfer belongings into the trust through documentation. Missing this step is common and costly, a costly mistake causing assets to end up back in probate court despite having a trust. Here are some frequent mistakes I see families make not funding the trust correctly. Assets left outside the trust still go to probate. Neglecting updates. Life changes, marriages, divorce, births, deaths must reflect in your trust documents. Misunderstanding trust types. Confusing revocable trust, changeable with irrevocable trust, generally permanent. Always work closely with a qualified estate planning attorney to avoid these pitfalls. Another critical player in this entire process, often overlooked, is your realtor. You might ask, how exactly can a realtor help during probate or when dealing with inherited property? An experienced probate and trust specialist realtor can simplify the process significantly. Here's what your realtor can do. 1. Accurate property valuation. Your realtor can help provide accurate market valuation to determine if you meet the $750,000 threshold under the new law. Accurate valuations can be critical to probate courts. 2. Property preparation and repairs. A realtor experienced with probate understands the homes often require repairs or staging to maximum sale value, which directly benefits your family. 3. Marketing the property. Probate homes often have unique marketing challenges. An experienced realtor knows exactly how to present these properties to attract serious buyers quickly. 4. Managing emotions and family dynamics. Inherited property sales can be emotionally charged. A compassionate realtor can act as a neutral mediator, reducing stress and facilitating smoother communications among family members. 5. Navigating legal complexities. Your realtor will work closely with your attorney, ensuring the home sale meets all court requirements. This teamwork helps avoid costly delays or complications. 6. Providing a network of professionals. A good probate realtor brings a team from appraisers and home inspectors to estate sale companies and property maintenance professionals. By hiring a realtor who specializes in probate and trust situations, you're gaining a crucial partner to make a challenging time much easier and less stressful. Imagine this scenario. John inherited his mother's California home valued at $720,000 after she passed in May 2025. Because it qualified under the new streamlined probate law, John's attorney easily processed the paperwork. But John also worked with a probate specialized realtor who quickly evaluated the home, coordinated necessary repairs, professionally marketed, and secured a strong buyer quickly. This collaboration saved John months of time and stress, significantly increasing his net proceeds. This example demonstrates perfectly how the new law, a good estate plan, and experienced realtor can come together to simplify your family's transition. In conclusion, while the new probate law, effective April 1st, 2025, greatly simplifies probate in many cases, a properly funded living trust is still the most comprehensive way to protect your family's future. Adding a trusted probate-savvy realtor further streamlines the entire process, ensuring maximum value with minimal stress. Your estate represents your life's hard work. Make sure you're fully protecting it. If this video provided clarity and value, please like, share, and subscribe. Drop your questions or comments below. I'd love to help further. Thanks so much for watching. I'll see you next time.